This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York.
This has been such a great collaboration that we've had with the Jackson Center, the Chautauqua Institution, ASIL, the Harris Institute, and Syracuse University, and we've had a number of teleconferences over the last few months as we put together this program. And I have to tell you, I do a lot of these conferences, and sometimes they don't go that smoothly, and this was always a pleasure to get on those calls. This is a really collegial, good group, and I hope we can work together much more in the future. On one of those calls, we were discussing who would get to introduce whom during the program, and the prospect of introducing Juan Mendez was on the table, and I jumped at it. Because I started my international legal career at Human Rights Watch, and unfortunately for me, I did not really overlap with Juan at Human Rights Watch, where he spent 15 years. But his ghost was in the place, and his tenure there was the stuff of lore. And every time it seemed I asked someone, why do we take this policy position, or why are we advocating this in this context, people would say, well, Juan developed that policy, or that's what Juan said, or Juan did it that way. And it was my regret that we didn't get to work together, and I'm pleased that we can now cross paths here. Juan is currently the president of the International Center for Transitional Justice in New York, a relatively new organization, but has quickly become really the preeminent non-governmental organization working in this field, doing research, analysis of what works in transitional justice, and very effective advocacy on those issues. He has also, while serving in this position for the last 3 years, been the special advisor to the Secretary General of the UN on the prevention of genocide. Before taking on those positions, Juan worked for 15 years at Human Rights Watch, where he was the director of America's Watch and then general counsel. He served from 1996 to 1999 as executive director of the Inter-American Institute of Human Rights in Costa Rica. And between 1999 and 2004, he was a professor at Notre Dame and director of the Center for Civil and Human Rights at the university there. Between 2000 and 2003, he was a member of the Inter-American Commission on Human Rights of the Organization of American States and served as its president in 2002. He's taught at Georgetown and at Johns Hopkins, and teaches regularly in the Oxford Master's Program. It's really hard to think of someone who has done more to advance human rights in the Americas, certainly in the last 3 decades. And not only has Juan been a tireless advocate for this cause, but he has done so at great personal cost. In the early part of his career, he as a result of his legal work on behalf of prisoners of conscience and political prisoners in Argentina, his native country, he was arrested and subjected to torture and administrative detention for 1.5 years. Amnesty International during that period adopted him as a prisoner of conscience. So we have here tonight with us someone who knows a great deal about our subject, is an expert in the field, and has lived our cause. And so it's a great privilege to have Juan Mendez with us, and please join me in welcoming him to our court.
Thank you very much, Betsy, for that very warm introduction. It shows that when you work in human rights, you make very good friends, and that explains the warmth and the exaggeration in some of the words that Betsy has just said. I have to say that I'm very humbled to be here in the presence of Nuremberg prosecutors, but also in the presence of current day prosecutors who are doing the work of breaking the cycle of impunity. That is my main concern at the International Center for Transitional Justice, and it's a big honor for me to be invited to speak to you, but it's a big honor for all my colleagues at ICTJ that you have asked me to render these remarks. I'm very grateful to the American Society of International Law, to the Robert Jackson Center, to the Chautauqua Institution, to Syracuse University, to the Whitney Harris Center at Washington University in St. Louis, and to the Planet Hood Foundation for this opportunity to speak at this very important dialogue. It's a great pleasure to be here tonight in front of all of you. My presentation concentrates on the importance of the prevention of mass violence and international crimes, including war crimes, and I will do so mainly from the perspective of the programs that the International Center for Transitional Justice carries on in several countries, but also from my recent experience as the former Special Advisor to the Secretary General of the United Nations on the prevention of genocide. Breaking impunity and fostering accountability is a crucial component in the prevention of future violence and mass atrocities. No prevention efforts can take place without a serious attempt to break the cycle of impunity for past human rights violations, especially if they are so widespread or systematic as to constitute war crimes, crimes against humanity, or genocide. The failure to do justice to the victims can lead to the desire to obtain revenge, and thus to more crimes. Accountability is essential to halt the vicious cycle of revenge, to enable the victims, their families, and communities to live peacefully with the communities that the perpetrators of atrocities claim to represent, and ultimately to avoid blaming the descendants for the crimes committed in earlier generations, but by those claiming to represent certain communities. Accountability for such crimes must be comprehensive, balanced, and holistic, meaning that policies and practice must address the need to discover and disclose the truth, to bring perpetrators to justice, to offer reparations to the victims, and to promote deep reform in the institutions through which state power is exercised. While criminal prosecutions should not be the sole response to impunity, there is no doubt that they must play a central, indispensable role in any policy of accountability. Prosecutions also represent the state's fundamental obligation to give victims access to justice. In addition, concerning international crimes, states have a clear international legal obligation to ensure that justice is done. This is particularly the case for serious violations of international humanitarian law. For war crimes, international humanitarian law, as defined notably in the Geneva Conventions and their additional protocols, establishes a duty for states to prosecute and punish those responsible or to hand them over to be prosecuted by another state party under the audedere aut judicare principle. As such, in the late 1940s, international humanitarian law created a new set of obligations, which in turn paved the way for the enforcement of these norms. Therefore, to fully foster accountability for such crimes, a dual approach should be favored. On the one hand, the international community must pay more attention to helping states live up to this obligation by building independent, impartial judiciaries that can prosecute mass atrocities with full respect for due process of law and fair trial guarantees. On the other hand, our support of the role of the International Criminal Court and other international or hybrid criminal jurisdictions must also be oriented towards supplementing the absence of will or capacity to produce fair trials domestically, but also to help generate that capacity in the future. This year we celebrate the 100th anniversary of the 1907 Hague Rules, as well as the 30th anniversary of the 1977 additional protocols to the Geneva Conventions. In the 70 years which elapsed between those two dates, 1907 and 1977, the world suffered 2 world wars, the Holocaust and other genocides, and many, many terrible war crimes. But these years have also marked the codification of the body of international humanitarian law, the materialization of the principle of individual criminal responsibility at the international level, and the strengthening of all forms of accountability for these crimes. the near universal ratification of the Geneva Conventions, as well as the recognition that many of their key provisions have acquired the status of customary international law, bears witness to this reinforcement of international law, and in particular of international humanitarian law. If we only just look back to less than 15 years ago, we see how far we have come from the pervasiveness of impunity for grave human rights crimes and from the permissive attitude towards that impunity by the international community. Many of you present here tonight have personally and professionally played a big part in these developments. Since 1993, we have notably witnessed the establishment of the International Criminal Tribunals for the former Yugoslavia and for Rwanda, of the Special Court for Sierra Leone, of the extraordinary chambers in the courts of Cambodia, and of other hybrid mechanisms in East Timor, Bosnia-Herzegovina, Kosovo, and recently Lebanon and Guatemala. Important too are efforts to prosecute these crimes at the domestic level, in places like Argentina, Chile, Peru, Colombia, Rwanda, and Ethiopia. The creation of the International Criminal Court in 1998 was the high point of this evolution, signaling that accountability for war crimes, crimes against humanity, and genocide is now paramount. But the Rome Statute is not only the culmination of a clear historical trend, it is also the means to establish an instrument that makes justice possible, even when the national domestic jurisdictions are unable or unwilling to afford it. And yet, for each situation in which the ICC has acquired jurisdiction, we hear voices calling for amnesty, withdrawal of indictments, or other forms of exercising discretion and avoiding prosecutions, supposedly in the name of peace. With the best of intentions, some are urging measures that implicitly give in to the blackmail of the parties to the armed conflict. Peace can only come if those accused of atrocities are given guarantees that they will not be touched. We are concerned by the revival of this debate that some of us had hoped was more settled by now. To those who have followed the evolution of human rights in the last 25 years, the debate rings of earlier discussions as to whether fragile democracies could really afford to investigate and disclose, let alone prosecute, the major crimes of the preceding era. The alleged antinomy between justice and democracy, often rephrased today as a tension between peace and justice, is debated among academic circles and also among practitioners. A major conference was recently co-organized in Nuremberg by the ICTJ with others to discuss this tension and to explore possible ways in which peace and justice indeed can be mutually reinforcing. In northern Uganda, while there is a broad recognition that the ICC arrest warrants have assisted in bringing the LRA to the negotiating table, some have portrayed those warrants as obstacles to progressing further with the peace process. We believe, however, that the warrants act as an incentive to keeping the LRA involved in the peace talks. We also welcome the signature of an agreement on accountability and reconciliation between the LRA and the government of Uganda that was signed on 29 June of this year. The agreement proposes that Uganda should implement its international obligations to prosecute senior leaders of the LRA under national law. Depending on what is proposed and implemented, we believe this may be consistent with the Rome Statute. A thorough national accountability process respecting international standards could have a wide-reaching impact in Ugandan society. We believe the robust approach taken in this peace agreement to accountability is an important improvement over past peace accords, and that the pressure brought to bear by the ICC has assisted to achieve this. At the same time, the international community must stand ready to continue its support to the ICC if either side reneges on the agreement. There are many examples of the impact that prosecutions, or even the threat of prosecutions, have in preventing crimes, including war crimes. In Côte d'Ivoire, the prospect of an ICC prosecution of those who used hate speech to instigate and incite to commit international crimes has arguably kept those actors under some level of control. It is also an important example of the possible preventive role of the ICC. In Colombia, the provisions on alternative sentencing and demobilization of the paramilitary groups under the so-called Peace and Justice Law, even as that law was strengthened by Colombia's Constitutional Court, would have left victims with even less prospect of justice for the harms they have suffered if it were not for the need to offer a semblance of compliance with the international standards set forth in the Rome Statute. At the same time, while the Peace and Justice Law shows important innovations, it also shows some of the tremendous challenges in dealing with large number of perpetrators and victims through a system that encourages cooperation with law enforcement and disclosure as an alternative to full-fledged trials. In Darfur, which I visited in 2004 and 2005 in my role as Special Advisor to the Secretary General on the Prevention of Genocide, impunity for earlier crimes, notably for the massacres of 2003 that cost 200,000 lives, has been for too long a factor of instability and a hindrance to prevention of future crimes. That is why early on I joined those who called for a referral of the case to the ICC by the Security Council, a measure of historic significance that was finally adopted on April 1st of 2005. What continues to be essential to the international community strategy is a multi-pronged approach to protection, to humanitarian assistance, to promoting a peaceful settlement of the conflict, and also to criminal accountability. Unfortunately, I have come away with the impression that we were not always strategic or sufficiently persistent in pursuing those four goals. It has now been over 2 years since the Security Council resolution referring the case to the ICC, and the government of Sudan has repeatedly stated that it does not recognize it and that it will not cooperate with the Office of the Prosecutor's investigations or the arrest warrants issued against Mr. Haroun and Mr. Kushaid. In that long period, the Security Council made no effort to remind the government of Sudan that this was a decision adopted under Chapter 7 of the Charter and therefore binding on all states. Instead, we have let the regime get away with defiance of a resolution adopted in furtherance of international peace and security. As far as I can see, only the High Commissioner for Human Rights and my Office of Prevention of Genocide have from time to time raised this point. The result is not only that we do not offer the ICC the support it needs, it is also that we have given away cards that we could have used in negotiating with Khartoum to better protect and assist the 4 million Darfuris who are now totally dependent on international assistance. In the Democratic Republic of Congo, reports of crimes are still surfacing, as for instance the massacre of Kasika. Many crimes are still being committed, particularly against women and girls, in a widespread manner, notably in the Kivus. Thus, the fight against impunity has barely started in this huge country. We hope that the trial of Thomas Lubanga Dilo will soon be followed by other cases so as to give an account of the many horrific crimes committed in this country since 2002. But there is also an acute need in the DRC to foster accountability for the many crimes committed before 2002. It is critical that domestic courts be enabled and empowered to try the responsible, including those bearing the highest level of responsibility. ICTJ is currently co-undertaking a survey so as to better understand the extent to which people have been victimized in the DRC. Another project which will pave the way to fostering accountability in the DRC is being developed by the UN Office of the High Commissioner for Human Rights in cooperation with MONUC, the mission of the United Nations in the DRC. It concerns the mapping of serious violations of international humanitarian law and of massive human rights violations which have taken place in the DRC over the last few years. Such mapping will not only gather and preserve crucial evidence, but also undoubtedly generate a new impetus to advocacy on the need to bring those responsible to justice. The long-term stability of this vast country situated at the heart of Africa is at stake, and much more needs to be done to ensure that the plight of the Congolese is addressed in accountability terms. What all these cases demonstrate is that ultimately the interest of justice and the interest of peace cannot and should not be divorced. Justice is an important component of the prevention of future crimes. It is only through justice and through enforcement of the law that long-term respect for the rule of law can be built. This provides us with an important lesson for all international and hybrid jurisdictions. They must seek more proactively to build their legitimacy in affected regions, so as to build their own relevance in the lives of those most affected. Most importantly, these jurisdictions are judged on the basis of their impartiality and professionalism. To be seen as legitimate and respectful of universal standards, there should be no perceptions of selective justice in the prosecutions. Those of us who support these jurisdictions should learn to identify their impact and successes in ways that go beyond the strict confines of the judicial process. In cases such as Cambodia, this will depend on the legitimacy and transparency of the extraordinary chambers in the eyes of both Cambodians who suffered under the Khmer Rouge and the international community. This broader impact is all the more important for those international or hybrid jurisdictions which are being prompted to complete, quote unquote, their work in the coming years. Now is the time to assess their work and also to review their legacy and what remains to be done, with a view to help generate domestic capacity to further their work. Of paramount importance is to bring to justice the leaders, those who bear the greatest responsibility in the commission of international crimes. Even heads of states are not beyond the reach of the law. These principles are reflected throughout international humanitarian law. On the one hand, the principle of command responsibility, and on the other hand, the fact that the official position of individuals does not relieve them of criminal responsibility. Of essential importance, too, is the need to continue to support domestic actors as they seek to bring justice outside of the spotlight of international attention or through the medium of the United Nations. In this respect, I want again to mention important efforts in places such as Chile, Peru, and Argentina. To conclude, the conduct of modern wars affects greater numbers of innocent victims than ever before, and the importance of condemning breaches of international humanitarian law and finding ways to enforce these norms is greater than ever. But one must recognize that preventing violations of international humanitarian law is an ideal which may never be completely attained. Justice, accountability, and punishment play important preventive functions, but they should not be overestimated. The fact that murders have been prosecuted domestically for centuries has not resulted in the cessation of murders, but the fear individuals have of being possibly punished may have a strong psychological impact correlated with the likelihood of being punished. And this may be one of the fundamental problems of international justice. It is not yet systematic, and there are still too many ways to escape it. This in turn shows the importance of the complementarity approach, the need to foster accountability at both the domestic and the international levels so that they ultimately reinforce each other. Situations such as Uganda and Colombia are showing us new ways in which this may be done in the future. Thank you very much for your attention.
I have the distinct pleasure and privilege to introduce an icon of our, not only of international criminal law, but our profession of law. I'm going to briefly highlight his biography, and what I want to offer to you is this is what Robert Jackson would call an American lawyer, someone who is committed to the law in whatever capacity that he does this. But as an aside, I remember when I first met my friend and colleague and my mentor, he's heard me say this before, and I'll say it again only because I love telling this story. I was invited to give the Klatsky Lecture at Case Western Reserve University back in the November of 2004, and I was coming back for some consultations anyway, but I flew all the way from Freetown, Sierra Leone, and landed in Cleveland, Ohio, sometime, somewhere. Michael Scharf, Professor Michael Scharf, greeted me, I think. I don't remember how I got to his house, but he had arranged right after I'd gotten off the airplane, somewhat comatose, for a nice dinner with Professor Henry King and a couple of his colleagues. We had a wonderful, wonderful dinner. It was the fall was just breaking, and it was just great to be home and to smell the cool air from Freetown. My colleagues know what that is like, and just the crispness of the air, the cleanliness of the air. And so we went into the evening, and we're sitting around having a little bit of wine, and I was just curious because I was still kind of coming down and still in the middle of all of this, of tasting, touching, smelling, feeling the horror. And I just casually mentioned to my good friend, I said, how did you handle the pain at Nuremberg? And he looks at me and he goes, about 2 scotches a night.
That's true.
There's a human side to all of this work as well, as you certainly can understand. But again, that is Henry King. Open, straight to the point, honest to a fault, and just someone who the next generation looks up to, like our colleague, Whitney Harris. These are the cornerstones. These are the people that make us feel that this all matters. And there are times, and my colleagues here know that, there are times when you're not really sure this is all worth it. But it is, by many things. Henry King is a professor at Case Western Reserve University. He's also U.S. Director of the Canada-U.S. Law Institute. He went to Yale University and graduated there with his LLB in 1943. He practiced law in New York right away at Millbank Tweed. That was a long time ago, Henry.
As far as I know.
Absolutely. And then he served as a Nuremberg prosecutor. Now, we have to put this in context. We look at these fine gentlemen who are a little bit more seasoned now. But, Henry, how old were you when you were at Nuremberg?
26.
26 years old. Can
It's
you
not
imagine?
too old, is it?
I'm sorry about mentioning your age. I'll never do that again. But can you imagine? 26 years old, and here he is at Nuremberg. And if you meet others or talk to other people, these were young folks and just beginning in their careers. And this is important to understand. Many of them weren't really sure whether they were doing the right thing. Like many of us, when we got those calls from whatever body was nominating us or telling us, you've been appointed prosecutor, I know I did. I wasn't sure whether I was making the right decision. Not because of the rightness of the cause, but again of just the perspective sometimes of the world related to international criminal law. Many people went off to Nuremberg, the first tribunal, not really sure whether this was a career-ending move, and took great courage. And as I tell my students at Syracuse University College of Law, you have to step through that door of opportunity, and it closes very quickly, within seconds sometimes. And you look through that door, and it's dark, you're not sure what it is, but step through it boldly and with a righteousness, and most times you probably not regret it. So enough said on this, but again, I just wanted to highlight the fact that, these people at Nuremberg, they weren't Brahmins. These people were young, working for a tremendous American lawyer who was focusing them, but again, they were very, very young. He came back and, as I look at his biography, he went back and he was corporate counsel for many years at TRW Corporation, left the international criminal law business. This is why I call him an American lawyer, because he can practice any law, anytime, anywhere. Not just do it, but actually do it in an excellent manner. He was the corporate counsel for TRW. He's the former chairman of the American Bar Association section on international law and practice. And this is a common theme that we see in a couple of our Nuremberg prosecutors. He's an author. He wrote an excellent book on Albert Speer, The Two Worlds of Albert Speer, which is just an excellent read. And he is the senior advisor to the Robert H. Jackson Center in Jamestown, New York. I could say much more, but what I'd rather do is turn over the table to our good friend, Dr. Henry King. Sir, the floor is yours.
Thank you. David, I want to correct the record on one thing. Scotch at the bar in the Grand Hotel was 20 cents a glass. I didn't want to have it go to waste. Yeah, right. I want to congratulate Greg and David Crane, Greg Peterson, David Crane, for a wonderful conference. They performed miracles in getting all this group together, and I think it's going to be memorable, and we may write some history. So I'm happy to be here. I'm going to talk on the spirit of Nuremberg, which is idealism. Harold Nicolson, a British journalist, came to Nuremberg to have a look at the proceedings before the International Military Tribunal. Later he wrote, quote, "In the courtroom at Nuremberg, something more was happening than the trial of a few captured prisoners. The inhuman was being confronted with the humane, ruthlessness with equity, lawlessness with patient justice, and barbarism with civilization," end of quote. In a few words, Nicholson captured the idealism which gave Nuremberg its forward thrust. Under the leadership of Robert Jackson, we had a vision of a better world, and we moved through Nuremberg to achieve it. It wasn't easy, because there were those, including Winston Churchill and Joseph Stalin, who wanted to avoid a trial and expedite matters through summary executions. Such a procedure would have not been a benchmark for a better world. Summary execution would have meant that the world had stood still morally, and that its leaders had not tried to build a world for a better future for all of mankind. But a public trial held significant risks. Germany had surrendered unconditionally, but there was fear that the defendants could use the trials to incite violence against the victorious powers. There is also a big element of personal risk for those such as myself who participated in Nuremberg. In my case, I gave up a secure legal position on Wall Street to participate in an undertaking whose outcome and impact on the future were unknown. The American public did not seem ready for Nuremberg. Isolationists and those just tired of the war saw Nuremberg as prolonging U.S. involvement. There were, in fact, many who attempted to dissuade me from going to Nuremberg because, quote, "you will lose your place in line on the avenue of success." The question each of us had to ask was, quote, "are those risks greater than the need to stand up against the Nazi atrocities and the possibility that they would be repeated?" Our answer was and still is no. Let's take a look at how Nuremberg became a reality. As World War II was drawing to a close, the Allied leaders needed to settle the question of what to do with the former leaders of Nazi Germany, most of whom were in the custody of the United States. As I've indicated previously, two important leaders favored summary execution. But on the advice of Secretary of War Henry L. Stimson, President Franklin Roosevelt leaned strongly toward a trial until his unanticipated death on April 12, 1945. The very next day, April 13, 1945, Justice Robert H. Jackson of the Supreme Court gave a speech before the annual meeting of the American Society of International Law, in which he advocated a trial, a fair trial. In his address, Jackson indicated that he wanted no part of a show trial designed only to convict. Convictions, Jackson said, should be based solely on fully supported evidence. If the evidence was not there to support a conviction, the individual should be acquitted. Jackson's observations on a prospective trial of the Nazi war criminals were acknowledged by the White House on May 2, 1945, when President Truman appointed him as his plenipotentiary in planning with the Allies for the trial of the Nazi war criminals. On June 6, 1945, Jackson reported back to the president outlining his plans for the substantive aspects of the trial. In his report, Jackson outlined the charges he felt should be the basis for the trial. The first crime was aggressive war, which was styled as crimes against peace. Jackson felt that this was a fundamental crime, and it consisted of the planning, preparation, and waging of wars of aggression and wars in violation of international treaties. The second charge recommended by Jackson was war crimes. These were crimes against civilians and prisoners of war in violation of the laws of war and customs of war. This charge was based substantially on the Hague and the Geneva Conventions governing the conduct of warfare, which most nations of the world had adhered to. The third charge was crimes against humanity, which dealt with multiple types of assaults on civilians, including in particular murder, persecution of individuals on racial, religious, and national origin grounds. This was indeed a sweeping charge, which was designed to reach all assaults on civilians not covered by the war crimes count. Hitler was once asked by his generals what the world would think if they killed every man, woman, and child in Poland. His response was, quote, "Who remembered the Armenians?" End of quote, referring to the Turkish army's genocide of 1.5 million Armenians beginning in 1915. The Crimes Against Humanity charge gave notice to the world that the world would no longer turn a blind eye to crimes against civilians just because they were committed by a sovereign state. Jackson also advocated a conspiracy charge to reach those who conspired to commit the foregoing crimes. He recommended that these atrocities did not, he recognized that these atrocities did not happen in a vacuum. Those most responsible often did not get their own hands dirty. But that should not prevent their being held accountable, consequently the conspiracy charge. By stressing the treaties and customary international law the Nazis violated, Jackson preempted the defense that Nuremberg was applying ex post facto law. It accomplished two things. One, it helped codify existing international law, laying the groundwork for modern prosecutions in the ad hoc tribunals and the ICC. But more important to those of Nuremberg, it reinforced Jackson's vision of a fair trial, not victor's justice. In his report to President Truman, Jackson also advocated the elimination of two prospective defenses by the Nazi war criminals. These were sovereign immunity and superior orders. Jackson felt that if these two defenses were allowed in combination, that no one could be convicted at the prospective trials because no one could be held responsible. As regards the sovereign immunity defense, Jackson thought there should be fullest responsibility where the authority was of the highest. No longer, he felt, should those who exercise authority in the name of the nation escape responsibility for their deeds. He recommended that they be called to full account. The second defense which Jackson wanted to eliminate was superior orders. He felt that the Nazi leaders who would be subject to trial should not be able to hide behind the defense that they were just obeying their superiors to justify their criminal acts. He felt that those who committed criminal acts should be called to account and punished for their action. He exercised great foresight in eliminating this defense, because in Nazi Germany, an absolute dictatorship, most important orders were issued in Hitler's name. Moreover, Hitler was nowhere to be found, having, as we later determined, committed suicide in his Berlin bunker on April 30th, 1945. The Lies met in London in early summer of 1945 to discuss Jackson's draft of a proposed procedure for the trial. The British and French did not request substantive changes in Jackson's draft, although the French disliked the conspiracy charge because they felt that conspiracy, to the extent existed, merged with the substantive crime itself. With the USSR, it was a different story. Their representative argued that the aggressive war count should apply only to the Nazis' action. The Russians wanted no generic approach to this count because they felt it could be extended to cover some of their own activities. Jackson, to a considerable extent, held a line on this one. The compromise reached in the London Agreement, Nuremberg Charter, called only for the prosecution of the Nazi war criminals, but the definitions were stated in generic terms, so as to be universally applicable in the future. Another issue was debated in London was the presumption of guilt or innocence. The Soviet Union wanted a presumption of guilt with regard to the defendants, while Jackson wanted a presumption of innocence. By insisting on a presumption of innocence, the burden fell on the prosecutor to prove the defendant's guilt and gave each defendant the benefit of the doubt, elements that are now widely considered essential for a fair trial. Here again, Jackson prevailed, and his foresight on this issue gave much increased credibility to the results of the trials. The next issue faced was the locale of the trial. The USSR representative wanted the trial to be held in Berlin. Jackson dissented and argued for Nuremberg, which had the largest undamaged courthouse in Europe. Moreover, Nuremberg was of great symbolic significance. It was the site of the Nazi Party headquarters and of the huge Nazi Party rallies where Hitler held forth in his challenges to the world. Nuremberg symbolized Nazism at its zenith, and it was important to correct the record as to the true implications of Nazism, which were indeed criminal. The next issue was the selection of the prospective defendants. Most of the defendants were in U.S. custody. On this issue, Jackson felt that for precedential reasons, they should be the leaders of each walk of German life, whether they be military or diplomatic, police or industrialists. Here, Jackson again prevailed, and it was he, working with the other allies, who targeted the individuals to be tried at Nuremberg. Joachim von Ribbentrop, the Nazi Minister of Foreign Affairs, found guilty on all 4 counts. Reichsmarshal Hermann Goering, commander of the Luftwaffe, guilty on all 4 counts. Gustav Krupp von Bohlen und Halbach, chairman of the Association of German Industrialists and major arms manufacturer using slave labor from occupied territories and concentration camps, indicted on all 4 counts, but not tried for health reasons. Julius Streicher, a publisher, who used his newspaper and children's books to incite anti-Semitism, convicted of crimes against humanity. In the matter of defense counsel, Jackson felt that Jackson took the view that the defendants should be well represented. He arranged for a Allied Control Commission to assume the cost of defense counsel, and also for such counsel be largely of the defendant's own choosing. The outcome of these negotiations was the London Charter of August 8, 1945, which provided the basis for the trial. One further point is important with regard to the presentation of the case against the defendants at Nuremberg. Jackson felt that as far as the U.S. prosecution was concerned, the evidence against the Nazis should be largely documentary from the Germans' own files. He felt that through this approach, the Nazis would convict themselves and that the result would have greater long-term credibility. Nuremberg officially began on November 20th, 1945. The real opening was on November 21, when Justice Jackson delivered the opening statement for the United States of America. In this statement, he set forth what Nuremberg was all about. Some high points are worthy of note. I should like to share them with you here today. First, Jackson stated that, quote, "the complaining party at the bar here today is civilization," end of quote. By this, he meant that the trial was to make a break with the barbarism of the past. Barbarism on so great a scale that it cost 50 million lives in World War II and had reached new limits of degradation never before experienced in history. Second, Jackson stated that the trial was, quote, "one of the most significant tributes ever paid by power to reason." By this, he meant that reason was now to be the order of the day, and that the guilt of the defendants would be determined through the use of reason in a fair trial. Summary execution of the defendants by the Allied powers based on their military dominance was not to be permitted. The force of law was indeed to replace the law of force. Third, Jackson stated, quote, "as we pass a poison chalice to the lips of these defendants, we pass it to our lips as well," end of quote. This meant that the trial was to represent equity, and that the allies themselves, who brought the charges against the Nazi defendants, were to be governed in their future behavior by the standards established at Nuremberg. Jackson felt that if Nuremberg was to have lasting meaning, the principles of Nuremberg should encompass benchmarks for the behavior of all peoples of the world, then and in the future. That indeed they should have universal application in the interest of fairness and equity. And some of what Jackson wanted to convey through the opening statement was that Nuremberg was to mark the beginning of a new era in human history. After all, he was indeed the architect of Nuremberg, and that was his vision, which is valid today as it was 60 years ago. Jackson's foresight in focusing on the documents from the Nazis' own files as proof of their guilt bore fruit in the judgment of the tribunal. In commenting on this, the International Military Tribunal said in effect that the Nazis had convicted themselves with the evidence submitted. The judgment was equitable in that 3 defendants were acquitted because the evidence was not there to support their convictions. The fears that people had before the trial had not been realized. Granting the defendants a fair trial, the right to publicly defend their actions, had not resulted in destabilizing the Allies' occupation and rebuilding efforts. Hermann Goering, who was seen by some as having gotten the better of Jackson during cross-examination, and yet he was still convicted, condemned not by clever words, but by the weight of the evidence. I came home from Nuremberg filled with the spirit of Nuremberg, but the public was not enthusiastic. And the bar turned its back on the recognition of Nuremberg for what it was, a complete break with the past. Despite having done well at the Yale Law School, then as now a top-ranking law school, I had trouble getting a job when I returned. This was in part because Senator Robert Taft of Ohio and others of his ilk had scoriated Nuremberg. In addition, the Cold War had intervened, and the U.S. and the USSR were engaged in a deep conflict on the issues of the day. With the ending of the Cold War in the 1980s, Nuremberg has, to a considerable extent, achieved the recognition it has always deserved. The Nuremberg Principles are being followed in UN-sponsored and other tribunals, and an international court has been established, which has been charged with the enforcement of what was substantively established at Nuremberg. In a number of areas of the world, a new regime of international human rights is the order of the day. Much progress has been made, but the United States, which through Jackson created Nuremberg, is fighting a rearguard action against the advances of the Nuremberg Principles. Jackson's position that the Nuremberg Principles should be applied in judging the conduct of all nations and their leaders is being disregarded by the United States today. The U.S. has turned its back on the International Criminal Court, which would institutionalize Nuremberg, and the U.S. has disregarded the Geneva Convention 1949 governing the treatment of prisoners of war taken in the course of hostilities by holding them without trial and subjecting them to torture. Progress is using our resources to create a better, more just world, not manipulating language and digging for loopholes to lower the minimum standards of decency. The fears that the world faces today are not new. Even courageous people, such as Winston Churchill, feared that by providing the Nazi leaders a fair and public trial would undermine the fragile security brought about by the Allied victory. Nuremberg faced these fears and proved that the rule of law is not such a fragile thing, that it strengthens democracies, even when applied to those who would deny it to others. Fortunately, the mistakes the administration has made do not need to be permanent. Relations with our allies have become strained because of the war in Iraq, but they are still strong alliances. France and Germany did not join us, but they have not attacked us either. We continue to work together in many ways for a better world. The abuse of Abu Ghraib revolted the civilized world just as they did American across the country. But the overwhelming response was not a call for America's destruction, but a plea for us to return to our core American values and freedom that we represent, our core American values. The lessons are clear. While some countries will hate us for the democratic values and freedom we represent, most of the world respects and looks up to the United States when we live up to the values we claim to hold so dear. What is needed now is a revival of the spirit of Nuremberg. A better, more peaceful world based on justice is within our grasp. With the major powers at peace, no longer staged at the brink of war, we have a golden opportunity to build a more secure future for generations to come. This was, in effect, our goal at Nuremberg, and we engaged at considerable self-sacrifice in our attempt to achieve it. I hope that there will be those among the current generation who will take it upon themselves to follow in our footsteps. So, let idealism and vision be the order of the day. We should always remember that committed individuals can and do make a difference. Let us use conferences such as this as a means to rekindle the enthusiasm which brought about Nuremberg. We can indeed achieve a better world if we will it to be our future. Thank you. I just wanted to add, I got condemned because I didn't follow. Wasn't concerned about not following the avenue for the achievement of success at the time I went to Nuremberg. But I'm an idealist, but I remember tremendously the fulfillment that I got personally from the Nuremberg experience. I'm at the twilight of my years, but when I look back, I feel that I may have some footprints, as I know Whitney has, that I did try to make a difference, that I was not concerned about myself, selfishly, but I was concerned about tithing for the welfare of others, both in this generation and for the future. That's the spirit of Nuremberg, idealism, set of goals. We need to kindle that with our young people. That's going to change the world if we do. So there's work to be done, but I thank you for your reception here today.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as Chief Prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646.